So, the government actually went ahead with it, and now here we are. Welcome to this video, which I will be posting on my YouTube channel. Suffice to say, this is a very long presentation, so I hope you'll stick with me through it all, especially considering there's a few areas in which may get slightly complicated. So, I'm Jeremiah, and this is the urgent need for an implied freedom to privacy, the under 16s ban. So, first of all, I would like to quickly just cover over some basic stuff, firstly about me and my qualifications in discussing this topic and why I will be talking to you about it now, given we are now a month into this ban. And even to call it a ban is slightly disingenuous to what it actually achieves. But again, we'll get into that later. In the second part, we'll actually cover the pros and cons of the Amendment Act itself. So we'll talk about ways in which I think they did all right with this amendment for a bill that was debated for barely 8 days, consulted for less than one, and then assented to fairly rapidly. But of course, there's some cons there as well, which we will need to discuss. I'm hoping that in the third to fifth section you will see where the sources of challenges for this this amendment will come from. Largely as a constitutional violation under the implied freedom of political communication, but I would also like to make the argument in part 6 regarding the need for an implied freedom of privacy. Now, this is something which I'm not sure if there is a lot of textual basis for, but I'm hoping that my argument will at least convince you to investigate the matter more, because, again, I'm not a legal expert, as you'll see. As well as, of course, in the final part, I'll share my personal opinion on the matter and what sort of drove me into making this presentation to begin with. So, let's continue. So, as I mentioned, a bit about myself. I currently hold a Bachelor of Information Technology in Artificial Intelligence and Cybersecurity. I have experience as a graduate information systems auditor, and I'm currently studying for my master's. I should also mention that I'm a Golden Key Lifetime member and a Westpac 100 scholar. So, now, as you probably got from the previous slide, I'm not a lawyer, so please bear with me as I interpret the various instruments and statutes of the Commonwealth and any other places that you will see where law has been stated. So, why am I talking about this now? It should be mentioned that there are currently 2 cases before the High Court, one brought by a Digital Freedom Foundation, along with 2 teenagers to give it standing, talking about the freedom of speech issue, and another one by Reddit, which I haven't had a look too much into, besides the fact that they are sort of more administrative focus on their application and their responsibilities under this act. So we'll see how those 2 cases go. But as I mentioned before, this ban is now in force, and given it's been about a month, the short-term impacts can now be observed, which, mind you, I think we can draw a bit more out of this than just what the mainstream media have been reporting on the subject. I should also mention that, however, that the mainstream media in general have seemed to miss the forest through the trees, and then spontaneously moved on, as it happens in this modern political landscape. It seems that foreign affairs seems to make all the difference. As you can imagine, a certain country invading another one and other matters certainly did not help this presentation in its development. So what am I saying in this presentation? And this is critical here. What I'm saying in this presentation is that the way the ban has been implemented is unsuitable with respect to freedom of speech, privacy, and cybersecurity requirements for the adequate preservation of identity information against threats like identity theft and the misuse of identification information. What I am not saying is that the ban is inherently wrong or always going to fail to achieve its stated aims. I'm just saying that the way it's been currently implemented leaves much to be desired. Let's talk about the Online Safety Amendment Social Media Minimum Age Act 2024. Now, my first impressions were slightly mixed. So, from a brief overview of the amendment and what it sets out to do, it appears well considered in most respects. However, its focus on punishments and various other matters are focused on companies rather than the individual. And in this way, it's not exactly a ban on the individual, it's just forcible incentives on the business to comply with what the government wants. And as you'll see in other representations that I refer to in this presentation, the media in general prefers to take the more drastic approach of calling it a ban. However, in my opinion, there is limited oversight mechanisms in the Act at present, which limits the opportunities for the government to apply these penalties, making the controls that they implement through this amendment less effective. And I think it could be quite detrimental, and you'll see where I talk about this later, because it's very important to cybersecurity that controls are implemented properly. Now, in the way the Act is strictly written, due consideration is given to the role of privacy. However, it's very superficial. Also, given the fact that the controls on companies could be ineffective, opens up the avenue for companies to utilize the identifiers mandated by law for collection purposes and others to undermine the key purpose behind privacy, which in particular provides the individual a limited right to anonymity or pseudonymity. And this is at Principle 13, if I'm remembering my numbers correctly. So whilst the purpose of this amendment is to improve child safety, and that is a valid purpose, the interference with the freedom of privacy and speech seems capricious. And that term essentially means that it's going beyond what is required, right? And that's what I'm trying to argue later on. The methods employed here seem to confound safety for protectionism, violating the fundamental option of individuals to anonymity or pseudonymity. The risks of this identification data being misused or even lost to hackers or fraudsters is critical. This does not seem to have been taken into account when considering the definition of safety, nor the full scale of the impact of such a breach. The language of the Act is clear and deliberate. The fact this wasn't sufficiently considered indicates that the full scope of what safety truly means might not have been properly considered by Parliament or the eSafety Commission during the mandate of its creation. Given plausible limitations on what kind of government identifiers can be used under Part 4A Division 2, it is possible that face scans may be the only form of identification available for the determination of age. If this is the case, and the system detects an incorrect age or age bracket, my primary question for the Parliament is this: will users be able to notify for correction under the Privacy Act Principle 13, and thereby will the information provided to the company under such circumstances be illegal, as per Section 63DA or DB? Which law prevails? I'm not going to talk about the Privacy Act explicitly in this presentation, beyond the fact that there are certain requirements that are placed upon companies to act appropriately, and those are the Australian privacy principles. However, there is some possible conflict between the laws in what they aim to achieve, and I don't think it's been properly considered. Again, I'm not a lawyer, so there may be some problems with my analysis in framing this question, but I believe that I am roughly on the right track here with regards to asking it. Now let's go into a pros versus cons. So, in short, reporting requirements do exist. However, the Commissioner is required to have reasonable grounds to suspect a company's non-compliance and then individually request from them the reports or information they require via a notice. And it should be mentioned that the scope of what information can be subpoenaed, effectively, is not set or explored in this amendment, leaving it unclear as to what could be effectively requested from the company in question. Beyond this is also observability of compliance issues regarding the Commissioner, because it's more de facto rather than legal, meaning we may not have sufficient mechanisms in place to ensure that we are aware of breaches with respect to Part 4A. Commissioners also do not appear to have any authority to prosecute organisations for their failure to properly handle the information they receive. However, the name and shame approach is used in Part 4A Division 5, which I'm not sure if that's going to be particularly effective against someone like, Facebook. Then again, Twitter's also been slightly problematic here too. Moving on. They've also done well in their definition of a social media platform in the sense that it exists. However, it is way too vague and capricious. Again, there's that word. By the scope of the definition as shown in green, this could theoretically identify any service which connects two users together, giving a lot of discretion to the government as to who to target. And this opens up avenues for selective prosecution or selective enforcement of the rules, given that it is entirely by legislative instrument rather than by law that dictates who is included, because the e-safety commissioner gets to choose. Not even, well, I mean, Parliament could override the e-safety commissioner, of course, but in most cases, the e-safety commissioner would be making these determinations. Let's continue then. There are also defined limits to the purposes for which a company can use the data they collect for the purposes of age verification. However, there is no observability mechanism in place in the Act to ensure that all companies are properly adhering to this purpose, hence relying on the information gathering powers of the Commissioner, which again require targeting and explicit reasonable grounds of suspicion regarding a possible breach. And I raise the question here, how can the Commissioner find reasonable grounds without sufficient observability to identify possible problems? And this comes from an auditing perspective looking at this Act here, because fundamentally you can have all the controls in the world in order to stop a particular bad outcome, but if you're unable to see whether something triggers that control or whether the control is even applied properly, well, you just can't be sure that it's going to function as intended. Now, I just want to highlight a small factor here regarding the reporting requirements under this Act at the moment. And I think this quote from the Honourable Justice James Edelman actually phrases it quite well. If the general character of the statute reveals that powers were intended to be exercised only for a particular purpose, then the exercise of the powers not for such a purpose but for some ulterior objective will be invalid. Where the power is one to obtain information, the general character of a statute will define the purpose for which that information can be used. And this is relevant to the reporting requirements under this Act regarding information effectively subpoenaed by the e-safety commissioner, right? So could powers aimed at obtaining information about for the purpose of ascertaining child safety on social media websites be used also for the purpose of ascertaining more fundamental cybersecurity and environmental safety concerns, vis-a-vis ensuring that the extant risk to the data is sufficiently mitigated? Essentially, my question here is whether these powers are sufficiently broad enough under the current interpretation of the High Court to allow for the interrogation of more fundamental security concerns, because it doesn't matter as much if you have all these safety controls that operate at the person or societal level, but if the technology stack that supports these exchanges or communications is unsafe or insecure, then that safety architecture could be violated. We need to have a holistic approach here, and it's not clear whether these subpoena powers, effectively, given to the e-safety commissioner, can be exercised for such a purpose. And if that is the case, then we have no observability on matters relevant to child safety that fall outside of the very narrow definition of child safety as found in the Act. And that is extremely disheartening to see. So, let's continue. What the Act does well and not well. So, the Act also explicitly targets social media companies for penalties. However, given the modern environment regarding age verification, I'm not certain if the Act appropriately punishes or legally limits the third parties involved in the process of this verification, as used by social media platforms. For example, consider KID or other platforms that may have age information or verification purposes. The same observability problem applies in this case, but more so as it's unlikely that a commissioner under the current Act would be aware of their commission by a social media platform. And this is incredibly dangerous to have when you have observability problems on top of observability problems, because at that point it just becomes a qualification. So, let's move on from the Act now, well, rather the amendment of the Act, and talk about where the challenges will come from, in my non-legal opinion. The High Court has provided a three-part test for determining the invalidity of an act based on an interference with the implied freedom of political communication, and that derives from the Lange v. Australian Broadcasting Corporation cases, as found in 1997 in the High Court. This essentially asks three core questions, the third one of which also has a few extra expanded parts to it as a result of the Liberty Works case in 2021. Now, the first part is this: does the law effectively burden the implied freedom in terms of its operation or effect? If yes to question 1, is the purpose of the law legitimate? In other words, does the law impose a burden as a consequence of pursuing some other purpose rather than having an illegitimate purpose of imposing the burden? This question essentially asks, is there a legitimate end to which this interference is trying to achieve? And then the third part of this test is the law reasonably appropriate and adapted to advance that legitimate objective? In other words, is it suitable, necessary, and adequate in its balance? As I mentioned, Liberty Works versus Commonwealth of Australia in the High Court expanded this by adding in that second part of the test there, by saying that suitability requires a rational connection between the law's purpose and the measures adopted by the law. Necessity requires an obvious and compelling alternative measure available, which is equally practicable and at the same time less restrictive on the freedom. And adequacy requires that the benefit sought to be achieved by the bill is not manifestly outweighed by the adverse effects on the freedom caused by the bill. So basically, the court in these cases has determined that part of the test is a matter of practicality as well as a matter of principle. And in this way, we can sort of weigh up the consequences of a decision in a more comprehensive manner. It seems reasonable that the courts would recognize that a burden does exist to the implied freedom of speech, as some valid citizens are losing access to their social media and continuing in perpetuity for new children growing up, and that as, per Part 2, the purpose of protecting children is a valid and legitimate purpose which does not impinge upon responsible government. However, I feel the courts would struggle to determine Part 3, whether it is reasonably appropriate and adapted to advance the objective, specifically with regards to the extended test developed in Liberty Works Inc. I feel that the suitability, necessity, and adequacy provisions can all be questioned. I'll explain how as we go. So, just to clarify for question 1, we can show clearly that a ban acts to limit participation, both of a political and non-political nature. The stakes are higher for democratic rather than administrative processes because participation in decision-making is a fundamental feature of Australia's political system. Public participation in decision-making is integral to a functioning liberal democracy. It is important for enhancing trust and ensuring the legitimacy of policy outputs. According to Robert Dahl in 2008, participation is one of the 5 core criteria for the democratic process which helps achieve the overarching liberal democratic ideal of political equality. If participation is compromised, then so too is political equality. While it is also difficult to escape the disinformation problem's shadow over the legitimacy of both inputs and outputs, in terms of actual interference, Australia's mechanisms of articulation are not easily accessed or manipulated by malign foreign entities. Processes of articulation are effectively safeguarded by digital analog hybridity, whereby analog mechanisms are retained and accompanying digitized mechanisms of public participation. Table 1 outlines some of the ways in which decision-making processes such as elections, referenda, departmental consultations, and petitioning are digitized, but also shows ways in which those processes remain defined by analog attributes. For example, a paper-based ballot system still predominantly defines voting, and protests might be organized using digital methods but still occur in person. The question for us in this matter of the ban concerns whether, through this social media ban, the imposition has impacted the political equality of all possible participants. As this ban quite clearly impacts the ability of teenagers to participate, we must conclude impliedly that the political equality between all citizens has indeed been violated. If the courts were to respect any principle as fundamental, it should be the equality of all Australians to participate in political discourse. It should be noted that under the Constitution's Section 117, this is already implied as a constitutional element. Given there seems to be very limited other avenues for a teen to engage in political speech, online social media represents an irreplaceable avenue. This would be different if politicians actually held town halls, for example, or other ways to keep in contact with their electorate, but as they do not, we need to work around them. Now, suitability requires a rational connection between the law's purpose and the measures adopted by the law. So, ostensibly, the Act overall tries to improve the online safety for Australians. Interesting wording there is for rather than of. It does sound a bit Big Brother-ish. However, there is a more important question. What is online safety? Keep in mind that question for later. Continuing, what are the purposes of the amendment? To reduce the risk of harm from certain kinds of social media platforms. As previously discussed, in my opinion, in the way the Act has been written, the definition of social media platform is already way too vague. So its apparent appeal to certain kinds of platforms falls flat with me. Continuing, I note that the risk they are protecting against here is against social media platforms themselves, arguably a strong purpose. However, I will debate whether this is the only purpose that need be considered. For instance, there is also a risk to all users of these platforms, resulting from this legislation in needing to provide identity information to verify one's age. Consider, for instance, the fact that most adults misidentified would probably use a driver's license to identify themselves to these services secondarily. These cards contain a whole bunch of other information alongside the core identity information and age information which was initially requested. This information is also incidentally put at risk by this legislation. What are the measures as related to the amendment? So, the current amendment's text, which has been passed and is now in force, is that there has been an imposition of a social media ban for individuals under the age of 16, impliedly requiring companies to screen all Australians for their age using ID or other means. Companies who collect data for this purpose of determining age cannot use that data for any other purpose. Except the Act doesn't state that, does it? The Act instead says that there may be other purposes as well for this data, which is a bit of a concern for me as a cybersecurity academic. Now, is there a rational connection between the Act's purpose and the amendment's purpose? I would argue between the Act and its own purpose. I would say that's not in question. Between the amendment and its purpose, I believe it achieves its stated purpose to block teenagers from accessing accounts, but that's an asterisk, as we'll get to later. However, the main question here is whether there's a rational connection between the amendment and the Act itself in achieving the Act's purpose. Does a social media ban for under 16s achieve the overall purpose of the Act in improving online safety for Australians? The question at the bottom there raises a core question. What is safety in this context? Secondarily, whilst I believe that the amendment achieves its purposes, as according to the objectives set out in Section 4A, there could still be debate on this point to which I'm not considering here, primarily for time reasons. This presentation is already very, very long. What is safety? And why is this question important? Because the definition of safety frames the primary purpose of the Act's amendment, to promote the safety of Australian children online. Thusly, to assuage any doubters who claim, "Are you not in support of child safety?" we must interpret what it means to be safe. However, there doesn't seem to be a single definition of safety in all of the Federal Register of Legislation. Isn't that amazing? However, some acts do define it in concert with other terms, implying definitional connection between them. First, let's have a look at the Online Safety Act's definition for online safety, as this would be the most legally applicable. Online safety for Australians means the capacity of Australians to use social media services and electronic services in a safe manner. What do they mean by safe manner? Is it the responsibility of the individual to operate in a safe manner, or do organizations have the responsibility to maintain the social media platform to ensure that users can use it in a safe manner? Is it behavioral on the part of the individual, or purely a business based methodology? If it is behavioral, how does this act ensure that those without the behaviors develop them? On the other hand, if it is implemented as a business based methodology, then one must ask, does such a focus actually achieve safety online? In other words, if this secondary view is correct, then does banning individuals from social media really solve the problem, or does it just move the crime or misdemeanors elsewhere? Can that be called an improvement as to the purpose of the act overall? Pragmatically speaking, a system which has any connectivity maintains, even if minimally, a risk to safety. This is why in cybersecurity the unobtainable gold standard of security is a computer which is powered off, down 1 kilometer under the ground, with no peripherals or connectivity, and surrounded by a lead box. Oh, and did I mention that the CPU wouldn't even work? Now, that doesn't sound very useful now, is it? Hence, we usually interpret security in terms of its trade-off between function and risk. Is this the kind of environment that the government intends for Australians to operate in? Is such an environment even conducive for free speech, political or not, or conducive for the privacy of the individual? However, there's a second definition here, as you'll see, and it says that online safety for children means the capacity of Australian children to use social media services and electronic services in a safe manner, and includes the protection of Australian children using those services from cyberbullying material targeted at an Australian child. A further question one might ask is how a social media ban achieves the second part of the online safety for children definition regarding cyberbullying material. In my opinion, the Act achieves this through other parts of its provisions regarding the reporting requirements. However, I have some other concerns regarding the writing of these sections, again regarding observability and the practicality of the individual nature of the requests. However, also a fundamental question of the text arises naturally. How are Australians, adults or not, supposed to demonstrate use of social media services in a safe manner if they are banned from them to begin with? It seems logically inconsistent to claim that a ban on usage would result in a person being able to use the service in a safe manner when they are granted access. Secondarily, by the terms of this second definition, online safety includes the protection of Australian children against cyberbullying. Is this inclusivity legally non-limiting? Should we consider other forms or ways in which we can protect children as being encompassed by this definition impliedly? I think so. Now, harm in the Online Safety Act appears as a threat to health rather than as that of safety. Such an interpretation raises a question: are health and safety related? Further, does threat include the implied threat of identity theft? In other words, if an identity is breached, or could be breached, then does that constitute a threat? By the terms of the definition of threat, it may be conditional or unconditional. In this case, I'd say the environment which supports identity theft is certainly conditional and can be made better or worse by policies made at all levels of government. TLDR, for most companies, this section of the Act applies if the entity holds information that is related to individuals and they are legally responsible for that information's privacy under the terms of the Australian Privacy Principle 11.1, security of private information against misuse, interference and loss, and against unauthorized access, modifications or disclosure. But basically here, if an unauthorized access to the information occurs and a reasonable person is likely to believe that such a breach would result in serious harm, or information is lost where unauthorized access is likely to occur, and assuming that an unauthorized access is likely to occur, a reasonable person concludes that the access would result in serious harm, then the breach is an eligible data breach of the entity and the affected individuals are at risk. So in some respects, safety can be seen as the absence of risk or harm. By this section explicitly, an individual would not be at risk if the person does not believe that serious harm has not or would not have occurred. But before we continue on with our explanation of what safety means, I just want to pose an argument to you. Presuming privacy represents the agency of an individual to choose, as is supported by the Australian privacy principles regarding anonymity, then by the compelled nature of the Online Safety Act regarding age-restricted social media sites, it could be said that the company's access to our personal information is unauthorized. By this logic, the government is facilitating the unauthorized access to our information, and is acting unlawfully by this provision, causing serious harm to us, the people, via the loss of our identity. Reading section 26WE Article 2A, if the above logic is correct, then the condition of subarticle A-I is met, and under subarticle A-II, if a reasonable person would conclude that access or disclosure would be likely to result in serious harm to any of the individuals to whom that information relates, in this case themselves, so the argument goes, what is the risk of such a breach? And secondarily, should the law allow and condone such a risk to safety even under the guise of other kinds of safety, even if such a kind is declared as paramount? As I've been building up to, the ideas of safety and health are cognates in law. Consider, for instance, the fact that the health of the individual was taken into account when discussing their safety. Thus, it could be said that safety is the preservation of the health of the individual through some sort of process. If you don't believe me, consider all the other kinds of cognates in law: to aid and abet, to cease and desist, to make null and void. These can be called legal doublets, and whilst not exact, this interpretation here seems plausible. This seems to follow a legal principle known as noscitur associis, meaning words are known by their associates. The fact that harm in this act is framed as psychological and physical suggests that this analysis holds some water. As this is the case, we can use other legislation of a similar nature to frame our argument. And this is where I draw in the Work Health and Safety Act 2011. It can be seen from Section 18 of the Work Health and Safety Act that health and safety is largely seen as a risk management enterprise whose goal is to mitigate risks which cause harm to persons. I believe we can apply a similar approach here for the Online Safety Act and its amendment. Applying this to the online safety for Australians definition, a safe manner would optimally be one devoid of risk. That is, usage of online services in such a way which is devoid of risk to their health or risk to their various rights and implied freedoms. Whether that risk is external from the corporations themselves who service a platform, from hackers who do all they can for their own purposes, or even interference from the government in the exercise of those rights. However, to ensure that the law is workable for businesses, the Online Safety Act makes reference to businesses establishing reasonable controls. This follows at least atmospherically from the Lang case, which, as mentioned, established this test. In fact, to establish this definition as plausible, it is quite simple to show the precedent that the courts have made in developing at least a partial understanding of the implied freedom of privacy. In this manner, a simple addition of a primary duty imposed on companies to act appropriately with this data is valid. However, the government must still act responsibly and with deliberate motion to ensure that platforms are complying with that duty via proper and fit-for-purpose oversight mechanisms, which, as I've mentioned, may not be providing adequate coverage in the amendment as written. Is there an infringement upon the purpose of the Act? In other words, would adopting these measures be acting counter to the goal, which is to again improve safety? To explore the potential infringement upon safety that these kinds of provisions under Part 4A could provide, we must assess the risk that threatens safety. In this respect, I've adopted the Work Health and Safety Act Section 18 as discussed prior to itemize the risk in a pseudo-legalistic and somewhat subject matter expert fashion. Hopefully this could be of some help in convincing a court. Wink, wink, nudge, nudge. The purpose of this part of argumentation is to take the test for infringement upon our freedoms in another way. The core case for an infringement against the implied freedoms relies on a rational connection between the law's purpose and the measures adopted by the law. However, if it can be shown that the measures adopted cannot achieve, or worse, put at greater risk the underlying purpose behind the law, it could be seen alternatively that the measures are unsuitable. This, as far as I'm aware, has not been attempted before, at least before the courts, so this is currently my speculation, though would suit the maintenance of a purpose-based pragmatic approach to the law. Speaking of which, I'd like to highlight a quote from a book that I've been attempting to read recently. By Stephen Breyer, it highlights what I believe is essential for courts to properly consider to ensure that the law benefits the people first, in accordance with a responsible and representative government. And I'll quote here. Law is tied to life, and a failure to understand how a statute is so tied can undermine the human activity the law seeks to benefit. Both cases came out the way they did because the court failed to ask the key purpose-based question: why would Congress have wanted a statute that produced those consequences? Putting the question in that way generates a better body of laws under which society can develop, and community life can flourish. Judges ought not to shy away from such considerations. So, the Australian Signals Directorate has been quite clear in their guidance. Australian organisations need to adopt a stance of when, not if, a cybersecurity incident were to occur. Granted, it may not occur to the specific subsystem responsible for this data, but the nature of modern threats is such that many will attempt what is known as lateral movement to find more valuable information in the network, and any information stored is therefore at risk. However, usually lateral movement relies on discovery, meaning that attackers need to invest time to investigate the topology and architecture of a business in order to determine what information or services are available. Given the way this act is written, notifications about inclusion in the age verification and restriction paradigm are made public, indicating to any potential hacker that identity-related information will be available in their system somewhere. Given most companies will want to lower costs, it is also likely that they will employ third parties to perform the verification and legal compliance, meaning that an interface may be exposed somewhere for this purpose. Hiding such an interface is not easy, and represents a weak point in security for threat actors to target. Further, whether or not an interface actually exists, or a third party exists to facilitate this purpose for a particular social media company, the Act functionally requires users to upload files or interact via a camera, and there is no functional way to prevent open source discovery of at least the surface level user interface and endpoints, which could then be progressively elaborated to discover related logic and data stores. Common patterns and compromises make it clear that the prior interpretation by the ASD and Australian Cybersecurity Centre is correct. Companies, even third-party service providers whose entire purpose is to process this kind of data, show a remarkable lack of cybersecurity. Considering, for instance, the fact that a social media company like Discord has a grand total of 2 data breaches over the past 5 years. Further, the fact that a service formerly provided by a private company, Jericho Pictures Inc., resulted in the disclosure of 2.9 billion individuals certainly indicates the risks of leaving such sensitive data in the hands of private companies is too great. The risks here largely come through social engineering and weak security controls which permit lateral movement. Whilst we do not know the precise nature of these incidents or the topology of these companies in question, the persistent nature of breaches imply that businesses may not be aware of unauthorized access until the data is already lost. Further, given that many adults use multiple social media platforms, the risk could be considered multiplicative, as the possible attack surface logically increases maximally across heterogeneous architectures, which by definition is further maximized in the case of fully disjointed supply chains. Given that social media companies are competitors, the chances that they share more than the core platform technologies, for instance, in other words, Linux-based servers, is low. However, sharing common platforms or services doesn't necessarily minimize the risk either, as it can act as a common source on which to deploy malware. This is why most malware targets the Windows operating system, as 76% of systems make use of some form of Windows according to StatCounter. Some may say, however, that the Act provides for a mitigation in the form of data destruction, naturally limiting the duration of the storage of the sensitive data to perhaps an hour, maybe a day at most, insofar as to the agreed purposes permit. However, I find a few problems with these mitigations. First, when is it actually concluded that a purpose has been fulfilled? If, from the provided document submitted by the user, their age cannot be conclusively determined in the first instance, do we presume that the data's purpose is fulfilled and thus should be destroyed by law, or is the purpose only fulfilled once the age of the user is conclusively determined? This latter interpretation could leave storage and the use of data for an indeterminate period in a still, as yet, lawful manner, which puts that data at continual risk of breach. Secondarily, the law does not provide for sufficient observability that subsection 3 is fulfilled. The law acts to say that organizations must, and yet fails to ensure that they do. By any auditor's judgment, we cannot be assured that the control is effective without sufficient observability in place. Hence, by the terms of risk management, we must conclude that the controls do not exist. After all, we cannot trust them to do the right thing, we must verify that they do. The sensitivity of the data involved is too great for reasonable assurance. We need total assurance on this matter. In auditing, we would call such a situation where we cannot ascertain whether a control is effective a qualification, something that is to be avoided and corrected. Thirdly, by the terms of the same subsection, if the data was originally requested for multiple purposes, including the purpose of determining someone's age, then the data can legally be retained for those other purposes, maybe, for example, including market segmentation or upselling mayhaps, then the data remains at risk for the duration of its storage, regardless of the legal requirement to delete it after its purposes are fulfilled, even presuming it is fulfillable by the terms of the purpose to begin with. Such sensitive material is too risky for non-government organizations to store in this context. No binding agreement exists as is the case in a corporate context, and the limitation imposed is not applicable until the end of the data's collected purpose, which again, some purposes may simply have no end date. While certainly there is a reasonable expectation to preserve the safety of the private and identifiable information which companies store, given the sensitivity of this data, the risks persist for the duration of its storage, and there is functionally no way to de-identify identification information by its very definition. Hence, destruction is the only way to remain compliant. Just for the sake of clarity, I'll just briefly show here the definitions of identification information and personal information. As you can see, the logic set out above is self-evident. You cannot de-identify identification information. So, you may mention the other control in the amendment. What government identification can be used to identify oneself on these services has, thus far, been absolutely prohibited. Instead, behavioral and video selfie identification methods are used in most places. However, what happens when someone is misidentified as being underage? In that case, they will need to provide identification to correct the record, and thus those records are now at risk. It seems reasonable to conclude that no behavioral or video identification method will be 100% effective, thus the risk is not fully mitigated, even in the most opportune case. Even if we assume 99% accuracy, which is still unlikely given the diversity of characteristics in the Australian population, there is still at least 200,000 people, based on a population of 20 million, which is undercounting it, whose information would still be at risk, at the very least. That proportion is massive already. So, what is the likelihood of this risk? Given the lack of observability on the controls imposed and the existing uncertainty around the precise workings of those controls that are there, we must presume them ineffective. Hence, the likelihood of the risk of unauthorized disclosure is certain. Let's now move to discuss the second part of the work health and safety test for, quote, the degree of harm that might result from the hazard or the risk. Let's first contextualize the scope of the risk. Quoting now from Cross and Holt in the Journal of Crime and Justice, described as a wicked problem, data breaches pose a real and ongoing challenge to the privacy of individuals and organizations globally. For example, The Privacy Clearinghouse, cited in Henday 2019, reports that there have been over 9,600 data breaches since 2005, exposing over 11,500,000,000 personal records. The incidence of data breaches, coupled with the extremely sensitive nature of the data lost and the number of records compromised, have increased so persistently that they rarely elicit any significant surprise or shock from the general public. In addition, individuals who perceive their breach victimization experience to be more severe were also more likely to report all four outcomes of physical and emotional well-being, financial and relationship impact. It is essential to recognize that any breach, regardless of the data lost, could be harmful to an individual victim and reiterates the lack of homogeneity in victim experiences. The experience of a loss of sensitive data, particularly from supposedly trustworthy entities, may directly contradict an individual's understanding of their personal safety and the way in which companies and resources are supposed to operate. In this way, the results indicate a benefit in recognizing victims of data breaches more as victims of crime, and potentially looked to victim support services that can assist individuals with the physical, emotional, and relational impacts of the incident, rather than an exclusive focus on the financial aspect. In reality, the potential risk today is amplified by the increased use of technology and the increased sophistication and quantity of attacks being faced. From this section, it is clear that identity theft and data theft are not just risks to the very present data in the system. There is an ecosystem of secondary effects which include the degree to which the individuals affected perceive to be the violation of their own safety through these supposedly safe companies and entities. Most public and private entities that are breached encourage individuals whose data was lost to change their passwords on any affected accounts, monitor their usage, obtain new pieces of personal information where it is possible, such as credit cards, licenses, or passports, and stay vigilant for potential harm. Additionally, some of the entities that were breached provided credit monitoring services for affected individuals for a specific period of time. Whilst these may be valid responses that reduce financial harm and reduce secondary victimization, they do little to address or minimize harms victims may experience to their life and well-being. It also continues to conceptualize data breach victimization as a homogeneous experience for victims and fails to account for the nuance of individual circumstance and how one perceives the severity of the breach. I'd like to jump in here and clarify that not all records or information are replaceable or repairable. Consider, for instance, information regarding facts that can never be changed. For instance, date of birth, certain biological features like hair color, eye color, and skin tone, within reason, of course. Once they are exposed, the harm is permanent. In the specific case of security-relevant identity features, this would be fingerprints, faceprint, gait, which is the way you walk, by the way, and retinal patterns. In the case of these elements being exposed specifically, the harm perhaps is most serious, considering how most people use at least one of these features to control access to their mobile device or for work. However, the risk isn't just to these devices. These devices usually also use these biometric prints as encryption factors in protecting other security keys for other accounts or purposes. Thus, the risk to secondary exposure is high. Unfortunately, the risk isn't static in this regard either. Generally, authentication is based on three things: something you know, something you have, and finally something you are. The strongest identity is formed and confirmed when all three factors are present in the authentication process. What risky policies like the under 16s ban do, by unintended consequence, is put at risk something you know and something you are. Something you know would be something like a password, and something you are, as I mentioned before, is fingerprints, faceprints, and other biometrics that you use to identify yourself. This is put at further risk given the limited controls or mitigations imposed by the law. We should be doing all we can to prevent the dissemination of these kinds of information to third parties. In passwordless architectures, authentication places greater weight on the other two factors. Again, something you have and something you are. Such a weighting increases the severity of this kind of risk. These kinds of policies delegate the age check to foreign corporations, which naturally increases the realm of required trust, meaning that both users and the government are trusting these corporations to do the right thing. And as I mentioned before, we have no observability to check if they are doing it the right way. So, if we were to put this in a deontological matrix between micro and macro level impacts, where the micro level is for the individual person and macro level was for the government or society impact, we can say that for the individual, the effect is critical. The loss of one's identity is extremely damaging, given it controls access to public and private resources like access to credit, loans, government benefits, housing, transportation, certain jobs, if not all, mind you, and of course taxation. At the macro level, it is more moderate. However, identity, when misused, can be used to manipulate and defraud the government. Misuse of identity could also undermine the national security of the nation through unintended exposure of intelligence operatives through their social media, which breaks their natural and required anonymity provisions. And misuse of identity breaks trust between individuals and the companies that they rely on for the carriage of services. This undermines integrity, opening up secondary risks to democracy. Therefore, overall, I rate this as a high degree of severity. Now we need to question how much the person knows about this risk, and I think it is quite telling that with respect to the first research question of this paper by Fizzle and Lee, they found that the majority of respondents in the sample did not perceive cybercrime generally as serious. With regards to the second research question, they found that only 30% of the sample indicated that they perceived cybercrime as serious when presented with the terminology, whereas nearly 34% of the sample indicated that they perceived cybercrime as serious when presented with the definition of the cybercrimes. These results, however, suggest that whilst more individuals perceived cybercrimes as serious when definitions were provided, the majority of respondents in the sample did not perceive cybercrime as serious. We postulate respondents' overall lack of perceived cybercrime seriousness may be a result of not knowing the precise details and consequences of online offences. In fact, it may be that a lack of understanding around what different cybercrime terms involve and a general lack of recognition around cybercrime's harmful consequences affect individuals' perceptions of cybercrime seriousness. Personally, I'd postulate that without clear, direct, and immediate education on the subject of cybercrime, most people's perceptions, as a reasonable person's intuition, does not reflect the reality of the situation. The risks of cybercrime have been partly explored by both research institutions and government agencies. However, governments themselves seem to lack the necessary knowledge to act on this advice and research adequately. In fact, instituting policies which actively hinder cyber safety in totality. Next, the study moved on into determining whether cybercrime misbeliefs impacted perceptions of cybercrime seriousness. The multivariate analysis revealed cybercrime misbeliefs to be a significant predictor of cybercrime seriousness, as the net of other factors, but only in the model where cybercrime definitions were provided. Individuals who more strongly endorsed cybercrime misbeliefs were significantly less likely to perceive cybercrime as serious when definitions of the offense were given. Similar to research on the relationship between the rape myth and acceptance and perceptions of crime, we argue that those who more strongly endorse cybercrime misbeliefs may not be sympathetic to victims of crime and may even blame them for their own victimization, thus viewing cybercrime as less serious. Additionally, cybercrime misbeliefs may have no bearing on individuals' perception of cybercrime seriousness when terminologies are presented, since there may not be enough information provided within the terms themselves to adequately form a meaningful opinion. A through line of this paper, I believe, could be seen to be the public's lack of understanding or comprehension of cyber risks and cybercrime. This would indicate that education, not prohibition, would be the best way of ensuring safety. Speaking of which, perhaps this is why cyber education programs, at least in the corporate setting, focus mainly on phishing and other related social engineering threats that are common in the corporate sector, rather than on a direct prohibition of the digital services which those attacks rely. In some way, the organizational context also provides us a proxy for something else as well. Usage of new technologies and services provides more value than its downsides, though most companies still seem to be underestimating the total impact of cyber threats to their organization. So, what the person concerned knows about this threat. They have limited knowledge about the hazards or risks involved in terms of both definition and terminology for the supermajority of people in Australia. Secondarily, and consequently, individuals on average would not be able to implement their own protections against such threats for the purposes of eliminating or minimizing the risk. So, hence, the duty of care imposed should be expanded as a result of this lack of knowledge. A question to remember for later, however, is who should this duty of care be imposed onto? I'd argue that both the government and corporations are jointly responsible for ensuring public safety in this regard, given the corporations provide the service and the government's entire purpose is to provide the regulations to make things safe. So, the final part of the infringement to safety test is regarding the availability and suitability of ways to eliminate or minimize the risk. Now, it should be mentioned that this plays into the necessity section of the Lang test, which we were discussing before, so I've deliberately limited the conversation here to governmental changes, which will only cover basic suggestions. The more extensive solution, which I believe should be adopted, will be presented later. So if we wanted to eliminate the risk, then we could not implement the age verification system, which mind you is free and was the prior position. However, it is not suitable at all because it does not achieve the objects of the Act in a better way, or at all. However, if instead we want to minimize the risk while preserving the current strategy, we could make a whole new identity card which only identifies age and core identity information. It would have a cost of millions to billions, and require some new legislation. However, it still reveals excess details about users which could be misused. And of course, it's another card, meaning that adoption by individuals as a hardware form of identification may limit effectiveness, and it's also unsuitable for privacy preservation in the digital environment as a result. However, a more integrated solution also could exist that beats out all the primitive ones suggested above. And that would be to take the concept of identity verification and handle that through a government portal instead. Now, some libertarians might call this digital ID and shy away from it as the communist ideal and whatnot. But when the alternative includes the expansion of the attack surface for all Australians in terms of cyber domain, this is arguably more suitable. In this particular case, the government would make a service which allows users to select an identity provider, for instance, My ID, or upload an image of an ID, for example, a driver's license or passport, to use during the identity check. This would use the government's already existing document verification service in order to actually process and return results, right? So half of this architecture is already there, free for us, not free, but available for us to use. Now, the government allows requested platforms, for example, the ones that the eSafety Commissioner says should be included, to participate in this scheme. I say participate, more like they're forced to participate. In which case, they would be able to interact with this service in order to get only the age information from an identity as processed by the DVS system, right? So, in the band's context here, we would implement an age bracket system which would confirm the user's age according to the table below. So under 9, under 13, under 16, under 18, over 18, and over 60. As you can see there, I'm thinking ahead that this could also be used for the seniors card program if the federal government wanted to sort of unify the systems together to make it more fair across the nation, given, after all, Section 117 of the Constitution does exist, and I'm not sure whether the independent schemes would technically impose a discrimination on certain users who are between the ages of 60 and 65, but that's a different story. We can get into that later. So, the suitability of this solution is relatively good. Whilst the cost is tens to hundreds of millions of dollars, it should be mentioned that this solution limits the amount of information that corporations get about a user, and is very clear that all they get is the age, no other information that could be used for identification purposes. However, there is still a risk here, and there are better ways of handling it. In saying that, the current solution is definitely not appropriate, and any cost is proportionate to the risk that we're trying to control. I say any risk, as if any amount of money is just available to spend, but I think you get my point, that the cost of such solutions that I mentioned here is relative pittance compared to the full budget of the Australian government. Thus, in my opinion, it is reasonably practicable for the government to implement stronger centralized controls to manage this cyber and privacy risk. Hence, the current provisions are not suitable or less suitable than other solutions. Now let's return to the Lang test here. So necessity requires an obvious and compelling alternative measure available which is equally practicable and at the same time less restrictive on the freedom. So, first of all, is there an alternative? Well, we'll get into that in a moment. Secondarily, is that stated alternative equally or more practicable than current measures? And finally, is the alternative measure less restrictive on the freedom? First of all, yes, there is an alternative. This is something I found through scrolling Reddit, so what fun Reddit is these days. This is the Parent-Child Digital Safety Link Scheme. It's a holistic public-private partnership which aims to solve all the problems of safety without compromising privacy or security. Given it is opt-in, parents could opt into the scheme, leaving everyone else unaffected. In this way, their freedom, everyone else's freedoms are maintained. Because it is parent-led, their children are fully under their control regarding how much risk they want to take on board, and there will be comprehensive controls with necessary oversight to ensure that the parent is always kept informed of their child's activity. Finally, as this is parent-led, accountability is placed with the parents to make the right decision, thus making it more targeted and adapted to the individual child in question. And as I mentioned, everyone else is just as free as they were before, in that way preserving the implied freedoms. To be clear, going back to this slide, the Parent-Child Digital Safety Link Framework is a sophisticated safety system, not a simple prohibition. It is a secure, opt-in, public-private partnership that gives parents the choice to supervise their children's online activities effectively. The core of the framework is a central, secure government hub, linked to MyGov for instance, where parents can register their child's devices. Online platforms are then required to check this hub and automatically apply a standardized set of robust parental controls to any account used on that device. I would also suggest deep and comprehensive cybersecurity protections against all forms of risk. In this respect, if possible, Essential 8 Maturity Level 3 would certainly be warranted. Given it is a totally new system, we don't exactly have a lot of technical debt to work with here, or rather to get in the way of what we want to do. Now, as I mentioned, it is parents empowered, with tools applicable across participating platforms in one place in one common format. As a result, parents are kept informed of their child's actions across all platforms. The Safety Link allows parents to proactively monitor their child's actions online and approve requests of a sensitive nature, for instance, making new accounts, engaging in new behaviors, or accepting friend requests if you want to go that far. Now, only the government can ask for personal information in this scheme, and thus is responsible for verifying the parent's identity through the portal only once, limiting the potential for scams rather than requesting that everyone input information into any which website they wish. Because after all, we have no trust that the companies, even if there is a company behind the screen, will perform properly with the data that they're given. Which also means that everyone else is not put at extra risk. Because if you're not participating in the scheme, your information is not at risk at all. Now, I mentioned before that limitations are implemented on the child's device. This entirely sidesteps a few common and a few uncommon methods of circumvention, increasing the effectiveness of the scheme. It also increases the privacy of the child as well, because the device itself becomes the gatekeeper, limiting child actions to only those which are pre-approved by the parent. Now, there's also peer-to-peer connections between the parents and child's devices, meaning that they link in a private and secure manner, regardless of any platform that wishes to intervene. This scheme can also be used in an educational rather than prohibitive manner. This means that parents set the boundaries of their child's learning environment, or their gaming environment if you want to be so extreme, and thus enable limited exploration and participation. For example, teachers in schools could uplink through this system to control special accounts for their students on platforms to enable educational outcomes in a time-limited and safety-first manner, of course with parental approval. There are many more parts to this holistic solution, so I recommend you watch the summary explainer video down in the description. So let's assess whether this alternative is equally or more practicable than the current measures. In terms of the government, unfortunately, what's more practicable than free? Not much. So, in terms of pure cost, if you're only going on the finances, the government wouldn't like this much because it would take a few $100 million given current charters. Further integration with government services permits the government to focus on what matters most: governance of the systems and definition of controls for implementation by businesses. This is their oversight function. Finally, the platform that is developed could provide the necessary metrics that the government needs to properly identify and control the effectiveness of the child safety controls online. This plays into the observability of the system and ensures that the government can properly report on the success and ability of the platform in achieving its desired outcomes. Now, in terms of business, it results in less exposure to risk as they're not storing any sensitive information. The integration with the system permits them to focus on what matters most to them, which is the controls in their product rather than the governance required to support it. And in terms of individuals, most individuals are not affected by this system, so the freedom of communication in the majority case is not impinged. Further as well, of course, privacy is not impinged either. In terms of parents, it lowers the risks to both themselves and their children, for example, to their identity and privacy, and one platform controls them all, making it simple and practical for them to use. In terms of the affected children, the impingements upon the freedoms are directed by parental consent, making boundaries and observability clear and understandable to both the child and parent. Further as well, it should be mentioned that as the parent is in control, again, these boundaries are not hard immutable bands. These boundaries are dynamic to the child's maturity level. So in this way, for the majority of users, which are not children of parents who have opted in, there is no imposition on the freedoms. Regarding children, the imposition is targeted, limited, and reasonably adapted to the parent's perception of the risk they will find on the internet. Overall, the alternative measure as proposed here is definitely less restrictive on the freedom a priori before we even consider the practical effect. Now, another matter to consider for a law, for example like the amendment, is whether the amendment is coherent with respect to our obligations under international law. For explicitly here, the International Covenant on Civil and Political Rights. As shown in the Human Rights Committee's General Comments number 34, it is clear that when a party state invokes a legitimate ground for restriction of a freedom of expression, it must demonstrate in specific and individualized fashion the precise nature of the threat and the necessity and proportionality of the specific action taken, in particular by establishing a direct and immediate connection between the expression and the threat. I believe our proposed solution here would be uniquely fashioned for the management of the threat in a manner which a simple ban on social media and/or accounts is inherently not. This derives from the fact that the amendment lacks a cogent, specific, and individualized set of threats to which it is protecting against, nor, as I've tried to show, the necessity or proportionality required to meet this bar under international law. As others can attest to, this ban does not operate in a manner which rationally connects a discrete kind or kinds of expressions to their respective threat, instead banning all forms of communication for users under the age of 16 through social media platforms. Some may say that Australia is not legally accountable to the Covenant, but this is simply not true. Not only were we parties to the Covenant, but also was entrenched in federal legislation through the Human Rights Parliamentary Scrutiny Act 2011 and permission under Section 51 to implement the required reforms under the Foreign Affairs and Treaties powers. The government cannot, and I mean legally, cannot violate a convention it has signed in good faith. Now, it should be mentioned that the Commonwealth Parliament has now enacted the Human Rights Parliamentary Scrutiny Act in 2011. The Act established a Parliamentary Joint Committee on Human Rights with the following functions: A. To examine bills for acts and legislative instruments that come before either house of the Parliament for compatibility with human rights, and to report to both houses of Parliament on that issue. To examine the act for compatibility with human rights and to report to both houses of the Parliament on that issue, and C, to inquire into any matter relating to human rights which is referred to it by the Attorney General, and to report to both houses of the Parliament on that matter. Moving down, the Act defines human rights as the rights and freedoms recognized or declared by the 7 core United Nations human rights treaties as they apply to Australia. These are by reference to the acronyms the ICCPR, the ICE-SOC, CERD, CEDW, CAT, the CORC, and the CORPD. I will note, however, that the Act itself is very short in comparison to what I expected. So if you'd like to have a look at the Parliamentary Scrutiny Act, it'll only take a few minutes of effort. It's literally 3 pages long. However, the significance of this definition cannot be overstated. Its practical effect is to require lawmakers to assess human rights compatibility by reference not to a closed list of rights, but to the well over 100 rights and freedoms contained in the 7 treaties listed. In this regard, the apparent lack of consideration could be considered in violation of this Act, except for the carve-out, as you'll see in subsection 5. After all, this amendment bill was passed in 9 days and had less than 1 day for public consultation. Does this sound like lawmakers have assessed the compatibility with the well over 100 rights and freedoms set out in the various ratified treaties? Further, for a government which is supposed to be acting in a representative and responsible manner, is this type of anti-transparent behaviour consistent? All acts should be required to provide this statement to help courts determine the intent of an act in practice, in manners which would impact the rights and freedoms of its citizens. Finally, we need to assess whether this Amendment Act has adequacy in its balance. Adequacy in its balance requires that the benefits sought to be achieved is not manifestly outweighed by the adverse effects on the freedom. Again, privacy is more important here, but communication is also relevant. What are the benefits of the current solution? As far as I can see, none. It doesn't achieve the goal of improving online safety for Australians. And what are the adverse effects or restrictions on the freedom? As we can see clearly, it hinders the communication of teens and tourists. The practical implementation of the ban creates other adverse effects regarding privacy and cyber risks as a result of requiring everyone to provide their ID, in the worst case. Is there a balance between the benefits and adverse effects on the freedom? From what I can see, no. It's not even limited at all in terms of its balance. The downsides quite clearly outweigh the positives. Now, I do want to quickly mention here that the Constitutional Clarion, who is run by Professor Emirata Tuomi, actually did a lovely video on Reddit's particular challenge to this social media ban bill, which, as I mentioned before, is not really a ban. And I think it's very important that you go watch her video because it covers some of the more in-depth legal analysis, which I simply do not have the expertise to cover here. However, some points I want to draw out from her video are relevant here too. As I've mentioned before, the ban is not a ban on engaging with the platform at all. It's a ban on holding accounts. However, that means that for platforms whereby access to content isn't protected by the account itself, for example, consider Reddit. You can view all the content on Reddit without an account. This ban, as if you could call it a ban again, does not fundamentally prevent the harm of a young person seeing the content because the content is still available. As she concludes, it is not reasonably appropriate and adapted to achieve the legitimate end of protecting young people from the harm that they may encounter if they go through the gate, in other words, to make the account. This is also, again, mainly important because only some platforms require accounts to access content and others do not. This creates a 2-tier system, really, between the platforms which do and the platforms which don't, and could impact upon which platforms teens choose to operate on. It also permits the social media companies to effectively strip away parental controls as they would no longer be needed, and it in this way would increase the risk of teens using these services, as parents would no longer have the ability to oversee their behavior online. Following on, the ban would instead have the most impact on expression, the practical effect of which it would amount to a restriction on the freedom of political communication. The constitutional argument for the amendment's invalidity is best set out by her, so I'd recommend watching her video again on the matter. And as she says here, quote, "To be valid, the law must be focused on achieving that legitimate purpose, in this case, protecting children from harm." Quote, "The amendment is a very blunt instrument." And also, quote, "It's important to note that young people do not usually have access to mainstream media to communicate their views. For instance, few 16-year-olds will have the opportunity to write an op-ed." So, to summarize the Lang test, in practical terms, the ban is unsuitable in terms of both the imposition on the freedoms, both communication and the one of privacy, which I would like to debate with you later, and secondarily, firstly, concerns of cybersecurity and risk management. In practical terms, the way the ban has been implemented is not necessary, as there are alternative methods of achieving the same outcomes in less privacy and risk-damaging ways, while minimally impacting freedom of speech. There is no adequacy in the balance between the harshness of the measures adopted and its stated benefits. Further, in practical terms, it results in harsher consequences for all of society's participants, which the test must take into account. Hence, the law is not reasonably and appropriately adapted to advance the legitimate object of the Online Safety Act, and does not support the constitutionally implied freedom of communication, nor a limited reading of a person's right to their personal privacy. So, now we get to the fun part where I get to attempt to define the need for an implied freedom of privacy. Now, but Jerry, I hear you call, there is no implied freedom to privacy. We have a Privacy Act, and not much else. And I hear you, I do. But if this case should demonstrate anything, it's that an implied freedom to privacy might in fact be required for the proper maintenance of a representative and responsible government. Now, if you've been a good student of the law and read through the Lang cases, you'll see that the proponent for the implied freedom of political communication does not construct their argument as an argument of an individual's rights, instead establishing them from implied necessity to the maintenance of a representative and responsible government. That is, a form of freedom of communication is necessary for the maintenance of a representative and responsible democratic form of government. Now, I'm not a lawyer, so I can't expand too much on the legalese used, but this at least makes sense in principle. A person unable to participate in the communication of political matters cannot reasonably be expected to operate properly as an informed voter, which is in the national interest to maintain. The Lang case in particular established that the implied freedom of political communication in Australia is a negative right, primarily acting as a restraint on legislative and executive power, rather than granting individuals a personal right. In a similar way, we can adopt such an implied necessity and negative right to define how privacy could be constitutionally supported. The challenge is, how do we do this and ensure that this doesn't just turn into judicial overreach? Well, the court has previously contended with the general idea of privacy in cases going as far back as 1937, but I think it's important to start here for one purpose. In the Australian Broadcasting Corporation versus Leonard Game Meats Party Limited case, privacy was seen as a recognition of human dignity. But that raises another question. What is human dignity with respect to the law? If it were up to me, with regards to privacy, it could be conceived as a combination of personal agency to decide if, when, and how personal information is shared. It would be the understanding that no human is perfect and mistakes can and do happen. Thus, human dignity is the preservation of the individual's self-worth in this framework. The idea that privacy may be essential to the preservation of human dignity is not a new concept, however. In fact, ever since the invention of the television and camera, the courts have dealt with cases involving the core ideas of privacy, as both statute and common law. Sir George Wyche's comments in this regard in 1937 certainly suggest that the court of the day may have held similar views to mine. But a step further, I'd posit, contending it as the space an individual needs to maintain their self-worth, in other words, their dignity and ability to participate in society adequately. Now, if you were more of a libertarian, Pico della Mirandola's perspective in his oration would make the most sense to you. In his perspective, an offence against human dignity would be an interference against a person's free will. In this respect, the imposition of laws controlling public behaviour could be considered an offence against a person's dignity. So this seems a tad bit too restrictive for the purpose of a functional society constructed as ours is. On the other hand, scholars put forward a societal focus on dignity. That is, dignity exists between members of the class, not in the individual case. Further, scholars like Rottenstreich extend this by natural implications that such a society-based conception of dignity defines dignity itself with respect to the normative behavior of that society. For instance, if the community were to consider that a particular matter is in the private domain, then the revelation of that matter would be an offence against dignity. In my opinion, such a conception would clearly put the protection of such a freedom of privacy within the scope of Chapter 3 of the Constitution, in other words, under the court's jurisdiction, matching existing precedents for the implied freedom of political communication. Suppose that we adopt the view that the desire for destruction is an expression of creativity, and, to that extent, accords with the notion of human dignity. That desire implies the annihilation or disregard of one's fellow man, both in the singular and in the plural. However, man's awareness of his dignity is joined by his awareness that dignity is not a quality of his, or of Paul or Peter only, but is an attribute of man qua man. In this sense, the awareness of human dignity presupposes a step beyond one's personal scope. It further presupposes the acknowledgement of their respective dignity of human beings in their plurality. Here, the very acknowledgement of the plurality of human beings implies a norm of behavior. From this point of view, we can see the relationship between human dignity and human equality. The demand for or right to equality is ultimately based on the notion that the human essence is preserved in every human individual. Former Justice Patrick Keane of the High Court highlighted the principles clearly. The people as a group are endowed with two inherent properties, civility and unity, which support their equality of opportunity to participate in the exercise of political sovereignty. It is from this foundation of limited textual basis in the Constitution that the High Court derived a freedom from interference regarding political communication, which I believe could also be adapted for the case of privacy. Quote, from the rather sparse textual basis of sections 7, 24, and 128 of the Constitution, the implied freedom of political communication emerged in Australian Capital Television Party Limited versus the Commonwealth as a means to protect the, quote, equality of opportunity to participate in the exercise of political sovereignty, which is an aspect of the representative democracy guaranteed by our Constitution. As the ties of the empire became more and more tenuous, and especially after the passage of the Australia Acts in 1986, an expansive reading of Sections 7, 24, and 128 of the Constitution met the felt need to relocate Australian sovereignty. As Chief Justice Mason observed in ACTV, the Australia Acts marked the end of the legal sovereignty of the Imperial Parliament and recognised the ultimate sovereignty resided in the Australian people. Following on from the basis recognised in the quote, such a freedom from interference with respect to privacy could be seen as protecting the inherent and equal dignity of all individuals of the Commonwealth, as a matter between individuals based on societal norms. I believe we could construct a similar constitutional textual basis to expand this as well. In due course, I will suggest that in later cases, the emphasis of the advocates who have sought to deploy the same technique in free speech cases in the High Court has shifted from a negative focus upon the legislature as the natural enemy of the people to the successful deployment of the argument that there is, in the values inherent in the concept of the people, scope for a positive role for legislatures in the protection and enhancement of popular sovereignty, and so of the implied freedom. With this shift in emphasis, the democratic values of civility and equal dignity, arguably inherent in popular sovereignty, were invoked to provide positive support for laws that burden the ability of some of the people to engage in political speech. I'd like to bring to you an argument which I think should solidify our idea of a freedom from interference regarding privacy in a societal manner. If, for instance, the revelation of some information would degrade a person's standing in society in the eyes of their peers, then it could be seen as an offense against the dignity of that individual. If that argument holds true, then by our principles explored above, it would also be seen as an affront against a person's privacy presumptively. Let's now see if we can find a textual basis for our freedom. So, in order to construct this properly, we must ensure that the inherent dignity of the people, big P, is maintained. That is, that the people have a unity and civility that supports a responsible and representative government. It is pretty clear from the preamble of the Constitution that the intention was to make, quote, one indissoluble federal commonwealth between the 6 original states. Unity, therefore, appears to be inherent beyond this implication. Similarly, unity inherently relies on the equality between members, or at least an assumption of reasonable equality, and this is supported explicitly in the Constitution by Section 117. Now we need to ask ourselves whether introducing a freedom of interference against privacy would support the unity of the people. I think that in a way it would. After all, if you consider for a moment that privacy acts to abstract unnecessary information from the conversation, limiting avenues for discrimination or other similar kinds of simple quips, potentially forcing the replier to actually engage with the argument posed, if one is indeed there to debate, I think we are onto something. Also consider the case of online messaging and social interaction. The pseudonymous nature of online communication naturally supports privacy, but also supports the unity of the people by hiding the unnecessary facts about the user. What's important is their opinion, not who they are. In some respects, preservation of dignity helps to preserve civility. Again, in some respects, respect can either be earned or, in the social media sphere, given by proxy of pseudonymity, promoting inherent civility in a very volatile and sometimes politically polarized public square. As former Chief Justice Alsop writes, by civility I mean manner of human expression and social intercourse that provides the environment for the exchange and debate of conflicting ideas. It is an environment of manners and peaceful willingness to see views and ideas of others. Civility and manners and social intercourse are not bourgeois affections, they are the necessary human customs for peaceful and respectful exchange of ideas. They should not be abandoned, whether through carelessness or for personal gain, or for any other reason. To do so impairs civil society's capacity to deal with difficult issues, and so impairs good government. Perhaps the court should consider the benefits of such an arrangement more closely regarding an implied freedom of interference against privacy than they have thus far. I think it's important that I highlight why I use the phrase pseudonymity rather than anonymity, as some people may get confused by the distinction. Anonymity is the quality or state of being anonymous or unknown. This is generally achieved online through the deliberate use of tools to mask identifying information, like a suitably distinct username combined with a VPN to mask your internet address, plus limiting what content you put up online to begin with. Pseudonymity, on the other hand, can be seen as a weaker form of anonymity, where insufficient clarity exists to clearly relate you to your alias. In regards to the internet, consider a suitably distinct username and limiting what content you post under that alias. However, it is usually still possible in this case to relate you to your alias given both enough time and enough signs. Most users operate under this regime. As to the suggestion that the court's decision in Comcare vs. Banerjee in 2019 permitted sweeping intrusions into the private lives of public servants, it must be remembered that the implied freedom of political communication could be said to be engaged at all only because of Ms. Banerjee's claim to be contributing to a public debate about matters of public interest. That it is difficult to enter the public square while at the same time insisting on one's privacy should not come as a surprise. To say this is To say this is not to say that anonymity is always inimical to free and fair political discussion, but the argument that anonymity of the speaker is always compatible with responsible government must come to grips with the concerns articulated in Smith v. Oldham that anonymity can be one of the natural enemies of responsibility. The courts have had to contend with this dilemma of privacy speech and maintaining a responsible government many times over the Commonwealth's history, and unfortunately, I don't have the legal knowledge to properly debate this to you. However, I do believe there is still room for the creation and maintenance of a freedom of interference from privacy deriving from the core provisions of the Constitution and existing precedent. Here's a part of the show where we get to have some fun and see my opinion. So if all you're here for is analysis, feel free to end here. But if not, I do have some pointed remarks I'd like to share with you. So, first up is an argument. If safety is the total protection of individuals from all risks regardless of likelihood or severity, then, by natural implication, the use of electricity is too risky, as it could set your house on fire. The use of piped water is too risky, as it could burst, flooding and destroying your property. The use of mobile phones is also too risky, as a battery could explode, given it's made of lithium, and start an unstoppable fire. The construction of a house also would not generally be worth the effort, as earthquakes, floods, and other natural disasters could destroy them. We also make the observation that the Online Safety Act social media ban is based on a conception that safety is just as absolute, in that all children must be protected. Therefore, the natural implication is raised that the use of social media is inherently unsafe, as to the fact that we still make use of electricity, water, mobile phones, and houses, and the majority of people still use social media relatively safely. I think we can argue that this conception of safety is not logically consistent. Therefore, the ban is based on this assumption is also not logically consistent. The argument I pose here is fundamentally one of reduction, specifically reduction to the absurd. I formalized it through a logic known as modus tollens, also known as denying the consequent, which means I've established several premises that if X is true, that safety is absolute, then Y must also be true, that we shouldn't use electricity, water, or the rest, as it's too risky. But as we observe ourselves accepting the risks posed by these technologies and make use of these utilities daily, the premise cannot be held to be true. In other words, making it an absurd precedent. Admittedly, if we were being philosophical about this, you could argue with me on whether the analogies made here are accurate, in reference seeing social media as a necessity of life. However, as I mentioned, I don't have the philosophical chops either to stand toe-to-toe with the best in metaphysics to argue that point. But if we can manage the risks of electricity, water pipes, and the rest without banning them, then we should be able to manage the risks of social media without banning that either. Let me give you a second better argument of mine as well. First premise. A total ban assumes that the expected utility of social media for children is always negative. This ignores the massive utility of connectivity, educational communities, and support networks for marginalized youth. By banning the service to prevent harm, you are also removing all of its utility, potentially causing a net negative result. A further premise. Further, much like electricity was for the Industrial Revolution, it is inevitable that digital communications are adopted and used, and it is a necessity for many reasons, including organization, sharing of thoughts and information, including political views, mind you, and for keeping in contact in an efficient manner, given the current delays on post and other forms of physical communication, especially over great distances. We also observe, however, that if safety is indeed the goal of this amendment, then a ban is logically self-defeating. A regulated environment allows for visibility, reporting tools, and moderation, also called safety features. A ban, like this, forces children into unregulated environments with zero or minimal safety features by comparison. Therefore, the ban increases the aggregate risk profile, undermining the core aims of the Act to improve safety. We see this already with some teens moving over to smaller app providers already, which again expand the attack surface available across smaller companies or providers, which may have insufficient resources to manage the cyber risks which they will now face. In conclusion, the total safety approach of a ban actually results in total opacity, creating a higher danger state than a regular managed risk approach. If any constitutional challenge were to be spontaneously developed by the courts in the current cases before them, I suggest that the most primitive and basic would be that the bill does not achieve its stated aims adequately, and thus should be struck down, especially in this case, as the amendment actively makes the challenges of digital safety worse. As the Americans can attest to with prohibition of alcohol, bans seldom work effectively. We need to establish and operate governance and observability platforms to enable us to use these technologies safely, not ban them outright. Also, mind you, was the original object of the Act. So, I just want to mention, given recent events in Bondi, it is likely that many people will want anything and everything done to secure our country against terror. But as I've highlighted in my slide on safety, such fervent pursuit of safety leads to absurd consequences when explored logically. Further, such pursuits do not occur without cost, both to the government in terms of their capital, because they need to pay for all the various services, including our own defence in other places, and providing support services to a large portion of Aussies around the country. In terms of the under 16s ban as well, however, companies are even more so constrained and their needs to be taken into account when giving them extra responsibility. Also, the early public releases coming from the intelligence community regarding this incident indicate that this was a lone wolf attack, a kind of attack with very few external signals to preempt it. I would just like to point out that by the nature of the covert work that our intelligence agencies can and do perform, that a grand proportion of all attempts made against this country are thwarted, and that is something to celebrate. In a similar way, the infrastructure that the world has developed to detect and counter cybercrime is already very strong and robust. In comparison to the internet that one would find in the 1990s, for instance, a lot of good has already come out of this industry for the benefit of all. Let us not let fear or misstated slogans on either issue before us in this time guide our thinking. Instead, let's look for the better solution, the inherently more robust framework for future success, ones which do not sacrifice that which makes us, well, us, our freedoms, our liberties, our political discourse, our inherent dignity as Australians. To do otherwise would be folly. As a final matter I'd like to raise before closing, in a world where access to parts of humanity's greatest resources are getting more and more gated behind official government documents, what happens to the few who don't have any? As cases like the one on the right demonstrate, that whilst the majority of citizens could see benefits from this kind of ban against social media companies, there is a minority of people for which this kind of ban would not operate appropriately, given the fact they don't have identifying information to work with in the first place. This could lead to a case where members of the class go without. We would expect, normatively, that such problems would be sorted out by the time they turn 16, but the presumption that all people have identity documents is not always true, and it should not be treated as if it is. And the presumption that those without identity documents are children is again wrong. And finally, to close out, I would just like to point out that in comparison to the defenders, attackers who want to abuse the current solution only need to find one vulnerability, one weakness. Depending on where such a vulnerability is in the tech stack, that could put at risk multiple companies' databases. Whether it is a zero-day vulnerability or a social engineering attack aimed at administrator credentials, we as users have limited remedies available, and no assurance of compliance with existing standards, much less those to be developed later. Now let's also consider the perspective of the defender. On one hand, we have multiple companies with multiple technology stacks and governance processes, increasing exponentially the attack surface and exposure of our sensitive information. On the other hand, the information we do provide is also contextualized by other information which was not requested, which could be used for the purpose of identity theft and financial fraud, on top of its primary purpose as age verification, such as name, address, license number, etc. The defenders are therefore obligated to protect these kinds of assets of the business and users as much as they are able, and that's asking a lot already, foregoing the additional challenge and expectation of their users regarding sensitive information. Whilst it takes attackers only one weakness, defenders have the grand challenge of having to defend all battlements simultaneously, and that is above anything else a losing fight. Eventually, there will be that one weakness which is exploited in a way nobody previously thought possible, or through poor organizational controls. All we can do is select ways which minimize the likelihood of a weakness being firstly found and then secondarily exploited. And that comes through assurance and careful proactive controls from the top and start. Also consider that as companies generally do not have a country's worth of resources to draw on, the amount of money even available in a corporation's budget to go to cybersecurity is surely much less in magnitude than that for which the government can ever consider paying. I have some grand ideas about how we could expand the cybersecurity and overall cyber posture of Australia, but this presentation is already long enough, and is besides the point. So, to conclude, in my personal opinion, the ban is unconstitutional on freedom of speech grounds, is also unsuitable given it undermines the object of the act in which it's been placed. There's also been insufficient consideration for the cybersecurity implications of the current methodology, leading to immense personal and corporate risk. And in my opinion, there are better alternatives out there, see the Parent-Child Digital Safety Link framework. Finally, whilst all that being said, some regulation in some form is certainly necessary in this space. There is no doubt about that. What I am debating here is the effectiveness of the solution decided upon. Again, a solution that was decided upon in 9 days of time and less than one of consultation. It is perfectly clear that the government tried to get this through without any sort of critique or criticism, and the gaps in the framework are showing. We need to fix this before it becomes a problem for all of us. Thank you so much for your avid listening or watching of this immensely long presentation. I'm certainly aware that many people's attention spans is almost next to nothing. Unfortunately, mine seems to be headed that way too, unfortunately. Whilst I hope the federal government won't make any more rash decisions impacting areas of policy that I have some familiarity with, I wouldn't mind continuing the precedent this video sets in terms of quality and topic. Comments on politics is something I prefer not to do, but commenting on areas of policy is something that I feel I could do more of in the future fairly easily. Regardless of what the future holds though, I do hope you enjoyed this presentation and hope that you got something out of it. If you have any questions, please feel free to put them down in the comment section below and share it around for those who you think would be interested or appreciate a dose of realism on this matter. Again, apologies for the delay given it's been a month, and presuming the fates align again, I hope to see you all next time. Thank you.